you choose to do this, not required, you go out of the normal order, so that's different. It's 4 times the size of the brief that the court wants you to file, 45 pages, and you do 165 pages. The judge herself said it was atypical. You introduce new evidence that is public, and you do this 32 days before the election. And Public Integrity said, just fine.
They agreed that our course was consistent and in compliance with the election year
Same Public
sensitivities policy.
Integrity said that all the toll analysis was just fine. Okay. Thanks.
Were you, during the pendency of the investigation, were you aware that at the Capitol on January 6th, FBI had confidential human sources?
I'm sure I probably was. I think there was public reporting on that.
But did you know that also as part of your work?
I'm sure, yeah.
Okay. And do you know how many there were?
As I sit here now, I can't recall. I know there was an Office of Inspector General report about this, that there were no undercover officers there, as had been reported, but there were informants there, some who had gone on their own.
And did your office oppose President Trump's discovery request for information relating to the confidential human sources?
I would have to look at our filings on that.
Okay. As we understand it, your office did oppose that and said any such information is not relevant to the charged conduct or as a valid defense in the case. And so consequently, you were not in favor of that. Does that refresh your recollection at all?
I'm not disputing what you're saying. I haven't read the filing. What I recall is there was also a database of evidence from January 6th that the D.C. U.S. Attorney's Office would give access to defendants who were involved in those cases, and we gave President Trump and his attorneys access to that. I'm not sure they ever accessed it, but
Okay.
I do recall that, and there may have been a filing like you talked about.
Okay. Let me make this an exhibit. The next exhibit will be number 12, and this is a letter from Stanley Woodward, Stan Brat, about the interactions they had with Jay Brat on August 24th, 2022, before you were appointed special counsel. You familiar with the allegations that Mr. Woodward raised about Mr. Brat?
Yes.
I'm going to refer you to 2 paragraphs in this letter. The first paragraph is the last one on page 1, and the second paragraph on page 2. And please, familiarize yourself with this. But I just wanted to flag in advance that I'm going to zero your attention in on those 2 paragraphs.
Yes.
Okay. This letter to Judge Boasberg from Brandon Woodward states that again, this is the last paragraph on page 1. Despite the purported purpose of the meeting, it began with Department Attorney Jay Brat referencing a folder of materials in highlighting Mr. Woodward's professional background. Specifically, Mr. Brat remarked that he was aware of the fact that Mr. Woodward had been recommended for a presidential nomination to the Superior Court of the District of Columbia. Mr. Brat also advised that the government's case against Mr. Nuada was strong, referencing his belief that one way or the other, Mr. Nuada would be giving up a lifestyle of private planes and private golf courses, and that it would behoove him, Mr. Nuada, to cooperate in the government's investigation. It was inappropriate for Mr. Brat to mention the fact that Mr. Woodward had been recommended for a presidential nomination to the Superior Court of the District of Columbia. The only rational inference to be drawn from this reference, combined with the assertion that the government's case against Mr. Nuada was strong, and that Mr. Woodward was not a so-called Trump attorney who would do the right thing, is that somehow Mr. Woodward's potential nomination to the Superior Court would be implicated by Mr. Nuada's decision not to cooperate in the government's investigation. Indeed, to the best of Mr. Woodward's recollection, Mr. Brat concluded his observations with words to the effect of, "I wouldn't want you to do anything to mess that up," referring to the potential nomination. It is, of course, noteworthy that the statements giving rise to this inference were coming from a senior official with the Justice Department. I asked you whether you had a recollection of these events, and you said you did.
I do.
Do you think it was inappropriate for Mr. Brat to make a suggestion to Mr. Woodward that, he ought to cooperate, and if he does cooperate, if Mr. Nuada chooses to cooperate, the implication was that his application to be, a judge will be looked on more favorably by the Democrats at the Justice Department?
I don't think that happened, but I'm happy to share with you my perspective on this.
Okay.
So,
And let me just say
Yeah.
one thing, if I may.
Sure.
These judges for the District of Columbia, the Justice Department weighs in on it. Is that not the case? The White House counsel's office, works to come up with the names they're gonna submit for a nomination. But the way the procedure works is the Justice Department, does the vetting.
I don't think I knew that until this issue came
Okay.
up, which I'm happy
Yeah.
to explain. So, with the District of Columbia particularly.
Right. Okay.
Very short time before this, matter of days, this is right around the time we had given notice that we intended to move forward with an indictment in the classified documents case of both Mr. Trump, President Trump, and Mr. Nada. As is my practice in cases like this, we gave Mr. Trump's attorneys an opportunity to come in and give me arguments as to why not to indict the case. And in the course of my life, I've heard those arguments and sometimes not move forward on cases. In this particular situation, because my decision would ultimately be reviewed by the Attorney General, who could countermand it, that meeting was with me and Bradley Weisheimer, who was in the Justice Department. Mr. Trump's attorneys were there. It was Jim Trusty, Lindsay Halligan, and there was a third attorney who I can't remember, but I'm sure there's a record of who that was. They gave reasons why they thought the case shouldn't be indicted. And for the first time, this is my recollection, they raised this issue that somehow Jay Brat had threatened Stanley Woodward. Now, I was surprised by this because we had interacted, I hadn't, but my counsel had interacted with Mr. Woodward numerous times over my time as special counsel. He not only represented Walt Nada, he represented other witnesses on the classified documents case. He represented, I believe, multiple people in the elections case. And so all this time passing, this has never been raised before. I went back to my office. That meeting was at the main Justice Building. I went back to my office, and very shortly afterwards, I informed my deputy, J.P. Cooney, about this and Ray Hulser about this. They contacted Mr. Woodward to ask him about this. I believe there are notes about that, notes of either J.P. Cooney or Ray Hulser. I'm not sure. My recollection of that, and again, they would remember this better, is that Mr. Woodward expressed surprise that anybody had raised this, and he said something to the effect of, well, I know how to make a complaint if I want to. Take that for what you will. That was the initial response.
What day was this?
Yeah,
What time frame, generally?
like early June, so like
Okay.
before the meeting with the attorneys was in the days before we ultimately went forward with the case. I'm not sure how late this letter was after this, when I came back to the office. I tasked Mr. Cooney and Mr. Hulser to speak to the people who were present for this meeting. None of them believed that Jay Brat would threaten Mr. Woodard. It didn't make a lot of sense that a career prosecutor would, in the first meeting with the counsel they never met, threaten them. One of the things they asked about was this issue about the judicial nominating thing. And Mr. Brat explained that he had not met Mr. Woodard before and not had a case with him, so he had looked him up. And when you pull up information about Mr. Woodard at the time, there's a page that comes up, and we attached this in one of our motions. It says Stanley Woodard Judicial Nominating Commission. That page makes it look like he is on, at least if you look at it quickly, on the Judicial Nominating Commission, not that he has a candidacy. Mr. Brat explained to us that he was under the impression that Mr. Woodard was on the commission and raised it as a sort of like icebreaker, like, I understand you're on this commission. Now, whether Mr. Woodard misunderstood that or some other reason, here he says he drew an inference that he was making some sort of threat. That didn't make a lot of sense to me, given all the interactions he'd had with our office. I think Mr. Woodard later started talking about a campaign against him, but he had meetings with people in my office repeatedly in positive ways. And finally, I also thought it was noteworthy that Mr. Woodard didn't bring up this issue for many months. And then the first time that he brings it up in this letter, he's doing it to seek strategic advantage, because he didn't report it to OPR, didn't want it reported to OPR, never asked that. And now he wants it not only reported to OPR, but he actually wants to delay the indictment of the case until that's concluded. I will say that when we confronted, I say we, my deputies spoke to Mr. Brat about this, he self-reported it to OPR, which is pretty standard in these sort of situations. And so, and I would also just say, this was some time ago, we did a filing on this that I believe is public, and that filing will reflect my best recollection of these things. And so I did not credit these allegations, but we made sure they were referred to OPR.
But